Well, we'll bring this session to order. We appreciate your being here with us. I see a lot of brain power in this session. The people who are in here are many fine thinkers and good lawyers. We have some who are not lawyers. Let me just introduce myself. I'm Gary Doxey. I'm an associate director at the International Center for Law and Religion Studies, and I teach in the history department at BYU, although I'm a professional law professor, that is a professional track law professor, but my teaching is in the history department, where among other things I teach about religious freedom in history. And so it's exciting for me to have a somewhat historical topic here, where we're talking about the Religious Freedom Restoration Act at 30. That implies some historicity here, some historical evolution, and that's indeed what we're going to talk about. I know we've got such distinguished panelists. I'm going to introduce them in just a moment, but I know we have a number of people who are not lawyers, or perhaps are not familiar with the Religious Freedom Restoration Act. So let me give a very brief background that I hope can be helpful so that we can follow this discussion better. So the Religious Freedom Restoration Act was passed in 1993, a true testament to the sea change politically we've experienced with religious freedom in this country, because in 1993 it was passed nearly unanimously. The lead sponsor, it was not, in other words, religious freedom was not yet political. The lead sponsor was Representative Chuck Schumer of New York. Orrin Hatch and Ted Kennedy were the big promoters in the Senate. In fact, Orrin Hatch considered it one of his great life achievements to be part of the passage of the Religious Freedom Restoration Act, signed by President Clinton to great aplomb. The public celebrated it, showing that at least at that period of time in the United States, religious freedom was a nearly universally appreciated right and understood by all and as not being political, but as being bipartisan. So anyway, we need to get some background for how that occurred. And for that reason, I just kind of remind all, I know the lawyers already know it, but most or many legal disputes about religious freedom come down to the question of where do you draw the line between religious freedom rights and other rights and interests. That's where lawyers make their money, on that question. Where are the limitation points? The legal definitions of these limitations have evolved over time, and the U.S. Constitution, another little reminder, has two main heads of religious freedom. One is the Religious Free Exercise Clause, and the other is the establishment, or really the no establishment clause, the prohibition against government establishing religion. We're going to be talking in this panel about the first, about religious free exercise, and specifically where are the limits on religious free exercise. During the generation prior to 1990, the Supreme Court had applied what's known as the strict scrutiny test, the standard for determining the limits of free exercise claims. That's the highest constitutional standard. In other words, if there's a thumb on the scale, it's in favor of protecting free exercise rights if the court is applying strict scrutiny. The strict scrutiny test means that government may not burden or infringe your right to exercise your religion unless the government proves that the government's action is, one, in furtherance of a compelling governmental interest, and two, it's the least restrictive means of furthering that interest. In other words, in lay terms, the strict scrutiny test makes the government prove that it has a really important reason for infringing upon your religious free exercise, and that there isn't another way to do it that's less burdensome. So the strict scrutiny standard, compelling state interest, and least restrictive means, was the standard the court used for a number of years, many years. This changed in 1990. Remember that Religious Freedom Restoration Act was passed in 1993. Why? Because of something that happened in 1990. In the case of Employment Division versus Smith, the Supreme Court ruled that the strict scrutiny test would not apply if the law or government action in question was neutral and generally applicable. That is, that the restriction applies to everybody, and your religious rights just happen to get caught in the wake of the government's action. Later, the court modified this stance and said that strict scrutiny, after all, would apply if the government's action actually set out to infringe your religious freedom rights. In other words, you were targeted because of your religion. But in general, the neutral and generally applicable standard was the new constitutional law on religious free exercise, and it meant in practice that religious free exercise was kicked off the constitutional pedestal and became more like any other policy consideration. With this background, we come to the Religious Freedom Restoration Act of 1993, also known as RFRA, RFRA, which people call RFRA. No vowels in there to make the part, but it's there, RFRA. Through RFRA, Congress re-established the strict scrutiny test as the standard protecting religious free exercise. But the story doesn't end there. In other words, the strict scrutiny test is not a cut and dried issue with the passage of RFRA, even though that's what Congress intended. But that's where I'm going to leave my part of this discussion out. This is where the story begins when we turn to our distinguished panelists who can talk about the RFRA at 30, the Religious Free Exercise Clause at 30. I have to my right, first, Joshua McDaniel. Josh is an assistant clinical professor of law and director of Harvard Law School's Religious Freedom Clinic, which is a pro bono program that gives students a hands-on supervised experience representing a diverse group of clients in First Amendment and religious freedom cases. Prior to joining Harvard Law, Josh was in private practice as a trial and appellate litigator with a particular expertise in First Amendment and religious freedom issues. After hearing from Josh, we'll turn to Daniel Kaminetsky, to the far right, who is general counsel of Agudath Israel, which is an organization that supports and seeks to strengthen community and religious life of Orthodox Jews. At Agudath Israel, Daniel leads legal efforts to protect the rights and interests of the Orthodox Jewish community and ensure that religious freedoms are protected in a diverse and evolving society. Daniel has a wealth of experience as a lawyer, including in helping litigate some of the more important cases defending rights of Orthodox Jews. Finally, we'll hear from James Phillips, who is the Constitutional Government Initiative Director and an associate professor at BYU's Wheatley Institute. James is a nationally recognized constitutional scholar and appellate advocate with sought-after expertise on the freedom of religion and constitutional interpretation. Prior to joining Wheatley, James was associate professor of law at Chapman University. He has also taught courses at BYU Law and was also a non-resident fellow with Stanford Law's Constitutional Law Center. We'll go in that order and turn to each of them, beginning with you first, Josh. Thank you.
It's really good to be with everyone. Gary did a great job of giving us an introduction to RFRA. I wanted to provide a little bit of context on religious freedom law in the United States so we could better understand this. In particular, I was there for Ryan Burge's remarks this morning. He was really excited about graphs. So I wasn't planning to show you guys this graph, but I was just really inspired by him. Felt like I had to do it.
Tough competition.
I don't have all those cool dots that he has kind of around the line, so I'm going to have to work on that. But this is my very unscientific chart of free exercise law in the United States. Beginning in 1879, actually, with is the first free exercise precedent that we have on the books. It's a Mormon polygamy case. Members of the Church of Jesus Christ of Latter-day Saints don't have a particularly stellar track record of winning cases in the Supreme Court on religious freedom issues. The Jehovah's Witnesses really have us beat out on that. They've won many more cases than we have. But you'll see, we start off on the far left with cases beginning late 1800s, moving through kind of the first part of the 1900s up through World War II era. The reason we don't see any cases before 1879, you would think we would have cases before that because we've had a free exercise clause since the late 1700s, is number one, there just were not a lot of, the Supreme Court was not taking hardly any First Amendment cases until that time. Really the only reason that, and the other big issue was that the First Amendment was not incorporated against states and cities and local governments until the 1900s. So that was a product of the 14th Amendment that was passed after the Civil War. Before then, the First Amendment applied only to the federal government and what the federal government did. Little piece of church history. I always think about when Joseph Smith went to, I think it was Martin Van Buren, and was pleading the cause of the Mormons who were being persecuted, and asked, what can the federal government do for us to protect us against these state and local officials? I think that when Martin Van Buren said, there's not really a lot that I can do for you, I think he may have been correct because of this nuance of First Amendment law, that the First Amendment did not restrict or did not apply to what states like the state of Missouri did, even if it was pretty blatant religious persecution. So these early cases, you'll see the chart is low. That means low religious freedom protection. So we've got Reynolds, we've got a number of draft cases, and Hamilton is related to the draft cases, involves mandatory military training in universities. And then we have this case, Gabitis, which involved Jehovah's Witness school children who were required to pledge allegiance to the flag. They thought that violated their faith, and the Supreme Court said national security trumped their free exercise rights, and so they lost that case. It wasn't until basically World War II that we finally start seeing some actual wins in the Supreme Court, mostly thanks to the Jehovah's Witnesses. So you have cases like Murdoch, and Barnett is a very interesting case because it's just 3 years. If you count Gabitis to Barnett, they're both Jehovah's Witness cases involving the Pledge of Allegiance, and it took just 3 years for the court to go 8-1 ruling against the Jehovah's Witnesses to ruling in their favor in the Barnett decision. And now the Barnett decision is a very important case in First Amendment law. But I'm going to move through this pretty quickly. The high point is Sherbert. So Sherbert is a decision where the Supreme Court adopts strict scrutiny for free exercise claims. And Yoder is another case involving the Amish where the court again reiterated that strict scrutiny protection. But then we see this downward fall until we get to the much maligned Smith decision in 1990. We have cases like Goldman in the military context where the Supreme Court says military can basically do what it wants when it comes to service members, and if it's restricting their religious freedom, they're mostly out of luck. Alone was from the prison context, so prisoners in federal custody or in state or local custody had pretty limited First Amendment protections for religious freedom. And we discussed in the last panel that was in this room, the Lean case involving sacred site protection for indigenous peoples. So loss in those cases. Then we get to Smith, and Gary talked about Smith, and Smith was widely criticized at the time it was announced, leading to this bipartisan push to pass RFRA. And the aftermath of Smith and RFRA is actually, you see a general, I would say, upward climb or trajectory where we have a lot of wins lately in the Supreme Court, both under the First Amendment, under the Free Exercise Clause, but also under the Religious Freedom Restoration Act. It's a revival of sorts of free exercise protection in the United States. When RFRA was passed, President Clinton signed it into law with nearly unanimous support in Congress. And when he signed it, he called it religious liberty the most precious of all American liberties. The idea of RFRA was to recognize that religious freedom is a fundamental, inalienable right that applies to everyone, and to extend that protection not just to majorities, not just to favored religious groups, but to all religious groups, even to religious minorities, and even to unpopular religious groups. And so over the years, we've had a number of cases. I'm going to kind of quickly go through this, and then I'll give just a couple of examples that I've encountered in my work with the Religious Freedom Clinic at Harvard Law School. In the Supreme Court, we've had a few cases. Actually, Chief Justice Roberts' first opinion as Chief Justice of the Supreme Court was actually the first case to uphold RFRA's constitutionality and to apply RFRA in a case on the merits. The case was called Gonzalez versus O Centro. Involved a small Brazilian Christian sect that wanted to use Huasca tea for sacramental purposes. And Huasca is a hallucinogenic substance and is on the list of Schedule I controlled substances. So the federal government said, no, you're going to get criminal sanctions if you do this. And so there was litigation that made its way to the Supreme Court. And importantly, Supreme Court ruled unanimously in favor of the religious claimants in that case. A big contrast from the Employment Division versus Smith case, which was also a peyote case, a Controlled Substances Act case, where the indigenous plaintiffs in that case lost the case. So you have here, I think somewhat symbolically, RFRA in its first case having a very different outcome than what you had under the Employment Division versus Smith case. And I think the important thing about that decision is the Supreme Court made clear that this is a very rigorous standard. So when the statute says that the burden is on the government, it really does mean the burden is on the government. It's a weighty burden. The government has to show not just that it has a compelling interest in general, it has to show that it has that compelling interest as applied to these particular claimants who are before the court. Another big case is the Burwell versus Hobby Lobby case involving the Hobby Lobby stores. The Department of Health and Human Services issued a contraceptive mandate. It allowed an exemption for religious nonprofits, but Hobby Lobby is a for-profit, closely held corporation held by very devoutly religious owners. And so the question there was, are they entitled to that protection? And if so, how should they win the case under RFRA's compelling interest test? And this was a much more controversial one, a much more narrowly decided case, but the Supreme Court ruled in Hobby Lobby's favor. And part of the reason it did so was because the way the regulations had been set up, the Obama administration had provided a means for religious groups and religious corporations and religious nonprofits to deal with this while still allowing contraceptive coverage for people that needed it in a way to kind of balance the interests on both sides. And so the Supreme Court basically said, well, RFRA says the government has to show that this is the action it's taking that infringes on a person's faith is the only way to do this. There's no less restrictive way that the government can accomplish its interests. And the Supreme Court said, well, you found a less restrictive way with respect to religious nonprofits. Why can't you take the same approach as to the plaintiff in this case? So those are the two big Supreme Court cases. There's another Supreme Court case involving Muslim men who were put on the FBI's no-fly list because they refused to spy on their religious congregations. The Supreme Court took that case to address a question about what types of remedies you could receive in religious freedom cases, but reaffirmed that there was a right in that case and that there was an entitlement to kind of the full range of remedies that you would normally be able to recover in a case. So just stepping back, how has RFRA been used over these past 30 years? It has been used in a wide range of cases. There's controlled substances cases like O Centro, the contraceptive mandate cases, which there were quite a few of them in the years following the issuance of those regulations. Those cases have died down quite a bit. You have, in recent years, you have vaccine mandate cases when they concern the federal government. You have appearance regulations. So, for example, if a prisoner wants to grow a beard, then court and it's a prisoner in federal custody, then the courts would look at that under RFRA. Employment claims, immigration claims, land use claims, eagle feather cases, religious speech claims, and dietary requests. So all kinds of cases. So I just wanted to mention a couple of cases, and I'll be very brief on this because I want to leave time to our other speakers and for questions. But in our clinic, how have we dealt with RFRA? So one context that we've dealt with this, so we discussed, Annika in the last panel discussed the Apache Stronghold case. That is a big RFRA case. So in these cases involving sacred sites that are on federal lands, because it's on federal land and because it's the federal government that is that is restricting the religious practice by destroying the sacred site, those cases are governed under RFRA, although the plaintiffs in those cases have not been particularly successful in winning those sacred site cases. Another really important context is the military context. So if you'll recall from my scientific graph, on the downward fall that we had leading towards the Smith decision, we had a case called Goldman, which was the case where the Supreme Court said basically in the First Amendment context, it was a Orthodox Jewish Army or Air Force captain, I believe, who wanted to wear a yarmulke while on a base, and the Supreme Court ruled against him and said basically there's tremendous deference that's given to military officials under the First Amendment. In RFRA, the Congress made the deliberate choice to apply RFRA standard even in the military context where traditionally service members give up a lot of their constitutional rights. And this has led to a lot of interesting questions about to what extent should deference still play a role under RFRA's very demanding standard. But just to mention one case that we in the clinic have dealt with is a case out of the DC Circuit Court of Appeals where we filed a brief in a case brought by some Sikh young men who were seeking admission into the Marine Corps. And the Marine Corps told them that in order to go through the 13 weeks of boot camp, they needed to shave their beard, which they grew for religious reasons, and they couldn't wear a turban, which they also had to wear for religious reasons. And I think one of the interesting things about this is that every other branch of the military had allowed these accommodations, and even the Marine Corps itself allowed this accommodation for Marines that were deployed and that were overseas. It was just within the 13-week time period that they were in the boot camp that they had to shave. So basically, in order to get through the door and have admission to the Marine Corps, they had to violate their sacred tenets. Once they passed through that, they could then they could grow their beard, they could wear a turban. So we supported that case, and there was a really great, strong decision from the DC Circuit in that case, ruling that the Marine Corps had to allow the exception for these 3 military recruits. So really quick, in terms of what are the takeaways from these 30 years, I think one takeaway that I have is that RFRA, I believe, proves Employment Division versus Smith wrong. One of the concerns that the court wrote in Smith was that this is going to open the floodgates. Religious claimants are going to win 100% of the time. The government will always lose. I actually, one of the perks of my job that is a little bit crazy is that Justice Breyer is a teacher at Harvard Law School, and so every once in a while I run into him, maybe at the faculty lounge or something like that. And when he finds out what I do, he forgets every time. Then I meet him the next time and I remind him who I am. But then we talk about religious freedom, and one of the things that he has mentioned to me is that he's not sure about Smith and whether Smith should be overruled because he's worried about this opening of the floodgates. But in my view, RFRA is basically a case study that shows when you apply strict scrutiny across the board as to all federal action, what happens. And the statistics bear out that actually the religious claimants don't win all the time. In fact, they don't win most of the time. And it's actually a very protective and important thing for religious minorities specifically. And then I would say the second and final takeaway that I would have is that RFRA rises and falls with polarization in our culture. So if you took my graph and you overlaid it on Ryan Burge's graph where he talked about the polarization in our country, and if you remember that he talked about 1990 was kind of the really good point where we saw a dip in polarization, but then it's been steadily climbing ever since then. Notably, you will see that that was also the same period of time when RFRA was able to be passed with this broad bipartisan support, but pretty quickly has devolved into becoming a much more controversial statute as the polarization has increased. So we go from ACLU supporting RFRA and being one of the proponents of it when it was first passed, to now the ACLU instructs all of its attorneys that they may not litigate RFRA claims because the ACLU is worried about creating precedents that could benefit Christians, which I think is way too extreme and goes too far. And I believe the solution to this, or part of the solution, or part of the way through this, is through pluralism, through recognizing the positive ways that RFRA benefits religious minorities, through standing up for people of other religious faiths. I think this is still an argument that can resonate both with people on the left and people on the right. And hopefully, I see this as kind of the intersection of the conference's two themes of peacemaking and pluralism. I think through that path of emphasizing the pluralism aspect of RFRA, I think that can help to build peace on this. So, thank you.
Okay. Pleasure to be here. My first time in Utah. I can't get over the fact that you guys get to have this view every day. It's something I would not get used to. So as mentioned, I work for an organization called Agudath Israel, and we're a national advocacy organization. And so one of the things that I do get involved in is advocating for the passing of legislation that preserves freedom of religion and our right to worship in the manner we have for centuries. And RFRA is a perfect example of that type of legislation. So it should come as no surprise, if you'll allow me to talk a little history, that we played a pivotal role in its passing. Now, I said we. I'm sure by the looks of myself, I was not involved. I was 15 and probably listening to Pearl Jam and playing hockey and driving my parents crazy. But my colleagues were very involved. And I also say that a little bit tongue-in-cheek because, as I've found in the advocacy world, when something good happens, everybody takes credit for it, right? And then you go to your donors and you tell them, look what we just did. But it's my understanding that there was a strong Catholic lobby against RFRA, and members of Agudath Israel had many meetings with William Cardinal Keeler and John Cardinal O'Connor to try to bridge the gap and get everybody on board. And it really was, as Gary mentioned, a unified type of legislation that everybody got behind. So I was asked by Gary to focus on some of the positives and maybe some of the failures of RFRA as it relates to our community. So why is RFRA so important to Orthodox Jews? Well, I'll give you two examples. So as was mentioned, RFRA was designed to protect against laws that are facially neutral towards religion but actually burden the observance of religion. So one of the elements of RFRA is that in order to trigger the strict scrutiny test, a sincerely held religious belief is being burdened. So usually the court often defers to the party saying that their religious belief is being deferred. But in a Fifth Circuit case during oral argument, one judge observed, we shouldn't defer on every single thing that somebody says. There have to be some actions that aren't sincerely held religious beliefs. For example, what if somebody said that turning on a light every day of the week is against their religion? Well, guess what, folks? From Friday night to Saturday night, I don't turn on lights. It's against the 10 Commandments to honor the Sabbath. So it's an example of what could be sort of an innocuous, generally applicable neutral law that for my community would be very, very problematic. And I'll give you another example. There's currently legislation being contemplated in various states, including, I believe, in Maryland, that every new construction has to have a feature where it has automatic lights. There are no light switches. Again, that's a problem. That's a problem for me on the Sabbath. I would have a very hard time being at BYU for the Sabbath. I wouldn't be able to use any of the faucets. I wouldn't be able to use the facilities because it's all automatic. And our religion holds that if you do something that triggers electric movement, it's actually against the Sabbath. So these are examples of real life examples of laws that RFRA could potentially help us with. It was mentioned, I'll just mention a few cases that bring out some of these other aspects that are very beneficial for our community. So it was mentioned about the Hobby Lobby case. So the Hobby Lobby case is very important, and I'm just going to amplify on what Josh said. Number one, it held that RFRA applies not only to individuals, but to corporations. In that case, that was a corporation that had a religious bent. So that's obviously important, for that it's not just applicable to individuals. The second aspect of Hobby Lobby has to do with abortion. So in the aftermath of Dobbs, abortion has become very politicized, obviously, and there are liberal states increasingly focused on facilitating abortions. In fact, I think it was California that attempted to pass the FACT Act. That was pre-Dobbs, in connection with National Institute of Family and Life Advocacy versus Becerra, which is actually a case that Agudath put in a brief. That was a case where California wanted to require certain types of pregnancy care providers to provide notice to patients about their contraceptive and abortion options. It was struck down as unconstitutional. And that was a First Amendment case, but it demonstrates the active attempts of government to infringe on an individual's religious beliefs that abortion should not occur. So under Hobby Lobby, it is likely that such legislation, if it compels individuals to act or facilitate abortion, that would be challenged as it relates to religious individuals utilizing RFRA. An interesting note about the Hobby Lobby case that I just found very fascinating. The government in that case argued that the substantial burden on religion had to be reasonable. And in that case, it wasn't, I think as was mentioned or alluded to, because the employees were not being forced to get abortions, only the option to purchase contraceptives. In essence, they were arguing that instead of viewing how this affects the religious party's belief, let's use the government's view as to whether this is really an important religious principle that's being transgressed. And obviously, the court rejected that argument and made it clear that the court had no business, and that's the language that the decision uses, questioning the reasonableness of a person's religious beliefs. The other case I wanted to mention is Religious Sisters of Mercy versus Becerra. That's a case in which the Eighth Circuit affirmed the district court's holding that RFRA protects insurance companies and healthcare providers if they decline coverage for and refuse to perform gender transitioning procedures, and that such actions do not constitute discrimination under the Affordable Health Care Act and Title VII. So again, this is a scenario that regularly comes up in the Jewish community, in that a Jewish doctor or a Jewish employer may not wish to perform such surgeries, and the Eighth Circuit recognized that such a belief is legitimate. Another case that I wanted to mention, we talk about is Braidwood Management versus EEOC. So after Bostock, we know that discrimination based on sexual or gender orientation was discrimination for the purposes of Title VII. So a major issue arose as to whether religious employers would be barred from discriminating against homosexual or transgender people under Title VII. So that was the issue in case of Braidwood Management, where an employer did not have an expressly religious mission. This was a for-profit entity, but the founder of, and the main, I guess, the person behind the company, Stephen Holtz, had very strong beliefs about marriage, about what's sexually immoral conduct, and he had a sex-specific dress code. He banned gender non-confirming behavior. Biological men must wear a professional attire, including a tie if they have contact with customers. Biological women may not wear a tie, but may wear skirts, blouses, shoes with heels, fingernail polish. Men were forbidden from wearing those accessories because cross-dressing was strictly forbidden. And quite surprisingly, or perhaps not surprisingly, although I don't know that every circuit would rule this way, but the Fifth Circuit ruled that RFRA required Braidwood to be exempted from Title VII because compliance with Title VII post-Bostock would substantially burden its ability to operate pursuant to its religious beliefs about homosexual and transgender conduct, and the EEOC failed to carry its burden to show that it had a compelling reason to refuse Braidwood an exception. And the language from the decision is quite strong. The language said that because RFRA operates as a kind of super statute displacing the normal operation of other federal laws, it might supersede Title VII's commands in appropriate cases. So again, very relevant to my community. We have very strict rules about dress, about other things mentioned in the decision, so a very significant decision. One area that we used RFRA in recently are autopsy. Under Jewish law, you're not allowed to perform an autopsy against a deceased person. And often there'll be a dispute, either there won't be a relative who is involved, or one relative wants an autopsy, but another relative says, look, they were Orthodox, they lived their whole life Orthodox, they really shouldn't be done. And actually there is a case, Johnson versus Levy, Tennessee Court of Appeals case, where the Tennessee equivalent of RFRA was used to stop an autopsy. We have cited RFRA just recently in a brief that we put in a few weeks ago, Landor versus Louisiana Department of Corrections. We cited RFRA. That's an RLUIPA case. RLUIPA was talked about this morning, but we cited RFRA because RFRA and RLUIPA have very similar language, and RFRA provides for damages. So we are arguing that RLUIPA should also have the damages aspect of RFRA. What are the failures of RFRA? So, one thing that I don't think has been mentioned today is that pursuant to a case, I believe, decided 3 years after RFRA, RFRA does not apply to state action. So, City of Bernie, right. So, obviously, many states have adopted RFRA statutes, but New York, Maryland, New Jersey, California, all very heavily Orthodox areas, do not have RFRA statutes. So if a state wants to pass a law, the RFRA analysis doesn't come into play. There may be other ways to challenge the law, but that is, I would say, a gap in RFRA that has sort of been, we can turn the failure into a success, because the fact that RFRA does not apply to the states gave birth, so to speak, to RLUIPA. RLUIPA state action in 2 instances is subject to the strict scrutiny of RFRA in terms of institutionalized persons, that is, people who are in prison, and zoning, which is a huge issue for Orthodox communities, because when you're Orthodox, you have to live near the synagogue because you can't drive to the synagogue. So it's often a fight about where you can build a synagogue, where you can't build a synagogue. RLUIPA has been a huge weapon for the Jewish community, and we really owe it to RFRA because RFRA spawned RLUIPA. So in a certain way, the failure was a success. That's pretty much what I wanted to speak about. And if you have any questions, if you had any questions about the citations, I'm happy to provide them after we finish.
All right. Well, I want to thank Daniel and Josh for being here. They flew from Massachusetts and New York, so some of our furthest traveling panelists. And I'm going to focus on kind of some current and future issues with RFRA, because after 31 years, we still have some unanswered questions. So I'm going to get a bit into the doctrinal weeds. I know that's a bit dangerous given we have allergy season right now in Utah, but I'm curious how many lawyers are in the group. I just kind of want to see what the mix is. Okay, all right. So I just briefly want to touch on something that was mentioned, and that was originally RFRA applied to all federal and state government action and laws. But in 1997, the Supreme Court said that the applying to state laws and government actors, and that includes local as well, was unconstitutional. Now, we won't get into that. It was underneath the 14th Amendment and the Congress's power under Section 5. But basically, RFRA was taken away as an enforcement against the states. Now there's another potential issue where RFRA could be unconstitutional in part of its application. And this is what's called the legislative anti-entrenchment principle. That is that one Congress cannot bind a future Congress. So let me start here with RFRA's text a little bit. RFRA declares that it applies now, after City of Bernie, to all federal law enacted before RFRA, but also after RFRA's adoption. So it extends forever in the past and in the future. But RFRA says, unless such later enacted law explicitly excludes such application. So in other words, Congress, if they expressly say, oh, this new law we just passed, RFRA doesn't apply, then RFRA won't apply. But if Congress doesn't say anything, then RFRA applies to everything that Congress passes. And the question is that constitutional? This was recently raised in the Apache stronghold litigation that Annika talked about in our last session, where the Biden administration, the Department of Justice, actually said, we actually don't think RFRA can apply to Congress's Land Transfer Act that they had passed after RFRA because of this principle that one Congress cannot bind a future Congress. Where does this come from? Well, the most recent iteration of this principle comes from a 2012 case called Doxey. In that case, the court said that statutes enacted by one Congress cannot bind a later Congress, which remains free to repeal the earlier statute, to exempt the current statute from the earlier statute, to modify the earlier statute, or to apply the earlier statute but as modified. What does the court cite for authority for this proposition? Well, they cite a case from Chief Justice Marshall in 1810, Fletcher v. Peck, where Chief Justice Marshall wrote for the majority of the court that one legislature is competent to repeal any act which a former legislature was competent to pass, and one legislature cannot abridge the powers of a succeeding legislature. So now you might be thinking, well, wait a second. So Congress is free to repeal the earlier statute. All right. Well, RFRA didn't say that it could never be repealed. So that doesn't seem to be a problem. To exempt the current statute from the earlier statute, well, RFRA expressly allows for that. To modify the earlier statute, sure. Congress can still modify RFRA if it wants to, or apply the earlier statute but as modified. That doesn't seem to be a problem. But then the next line in Doxey says this, and Congress remains free to express any such intention either expressly or by implication as it chooses. So in other words, the Department of Justice was arguing that this later land transfer, if it's found to violate RFRA, even if it doesn't say that it expressly exempts itself from RFRA, Congress must have implicitly meant for it to be exempted if they pass it after RFRA and it's in conflict with RFRA. In other words, that language in RFRA, that later statutes are only exempt if Congress expressly says so, has no effect. And that's the argument. Now, this would apply way beyond RFRA. So many federal statutes have this requirement in it. For example, the Administrative Procedure Act, the APA, says that no later statute will supersede or modify certain provisions in the APA relating to administrative law judges, except to the extent that it does so expressly. Again, we have this very same provision, and it's in dozens and dozens of federal statutes, including some major ones. So it's not just a RFRA issue. Now, only one court, a court of appeals, a federal court of appeals, has weighed in on this issue so far. In 2013, the Seventh Circuit held that RFRA didn't violate this legislative anti-entrenchment principle, although, to be honest, the reasoning wasn't super deep. They just basically said RFRA accounts for this principle because the statute does not apply to a subsequently enacted law if it explicitly excludes such application. So in other words, they said by including that in there, they've accounted for it. That may be true if you're taking a narrow or a weak view of the legislative anti-entrenchment principle. If you view the principle to mean that Congress can't forever prohibit something, can't say, future Congresses, you can never do X, well, RFRA doesn't do that, right? RFRA just says, when you're going to do X, you got to say so. It's kind of a clear statement rule for those of you who are familiar with that concept in other areas of the law. But if you take a strong version or view of the legislative entrenchment principle, then anything that Congress requires a future Congress to do is, in a way, putting a burden on them. And so it'll be interesting to see which version of that principle, when this eventually makes it to the Supreme Court adopts. What is the source of this principle? Well, it comes over from England, from British parliamentary supremacy. That's a little bit different constitutional system than we have. Congress is not the sovereign of the nation. The people are. And so it's a little unclear exactly how that principle applies in our context, but it certainly has been in case law since at least 1810 And so there is some precedent for it. If, when this goes up to the court eventually, and if the court were to decide that this principle means that RFRA cannot apply to later enacted statutes, that would hobble RFRA somewhat. It wouldn't completely gut RFRA, just like saying that it doesn't apply to the states didn't completely gut RFRA. RFRA would still apply to federal regulations because those aren't promulgated by Congress. It would still apply to executive action, and it would still apply to statutes that were enacted before RFRA. And as we're going to see on a panel a little bit later today, a lot of the threats to religious liberty today come from the administrative state, and so that would be untouched if the Supreme Court were to apply this legislative entrenchment principle to RFRA. So that's a big deal. The RFRA could potentially be held partially unconstitutional again. One other quick little issue that's percolating the courts, there's actually a three-way circuit split on this, is whether RFRA applies to a lawsuit between private parties. Where we often see this come up is someone will bring a lawsuit, usually under federal law, against a religious organization. And the religious organization will raise RFRA as a defense. That if you apply this federal law against me in this context, it will actually substantially burden our religion. There's a three-way circuit split. So 3 circuits, the 8th, the 2nd, and the D.C. Circuit, seem to allow RFRA in a lawsuit that's just between private parties. So, for example, the 8th found that the bankruptcy code was sufficiently burdening actually a couple that was wanting to pay their tithing to a church, and that wasn't allowed. So they allowed it in that context. The 2nd Circuit noted that RFRA's language is pretty broad, and if you look at, I'm just going to point out one piece of language here. This is actually the purpose, one of the purposes of RFRA in RFRA. It says to provide a claim or defense to persons whose religious exercise is substantially burdened by government. Doesn't say how it was burdened, right? So the 2nd Circuit said the language seems broad enough to allow it. The D.C. Circuit also allowed it in a kind of a weird context where both a private party and a federal agency were bringing a claim against a religious university, so a little bit different. The 5th, 6th, and 7th Circuit say, no way. You can't raise RFRA if the government's not a party. They point to language that says that RFRA it can be used as a claim or defense in a judicial proceeding so that you can obtain appropriate relief against a government. And if the government's not a party, are you really obtaining relief against them? Now, interestingly, the 2nd Circuit read that same language to actually be broadening rather than restricting. So again, the courts are kind of all over the place on this. And then the 9th Circuit kind of takes this middle position, which maybe we're not used to from the 9th Circuit, and they say that they'll partially allow RFRA under the circumstances where a plaintiff establishes a sufficient connection between a private entity and a government actor such that it seems like it's almost a joint activity between the private entity and the government actor. But only in the context of a RFRA claim. They haven't addressed whether or not RFRA could be a defense. And the statute does allow RFRA as both a claim and a defense. So the courts are going to have to sort this out, and eventually the Supreme Court is going to have to just decide this. Can you raise RFRA if the government is not on a suit? I think there's fair arguments on both sides. Certainly there are things in the text you could point to that would seem to say, well, maybe this only applies if the government's a party. But on the other hand, there are things you can point to and to the fact that the government can burden your religion even if it's not bringing a lawsuit, right? It can create private causes of action and then walk away and let someone else bring the lawsuit against you that burdens your religion. So we'll just have to see. And with that, we'll turn it back over to Gary.
Thank you very much. It looks like we have just a little bit of time before our break for some questions, but I want to turn first to the panel because as this has happened, each of these folks has been churning away with making notes, and I know they have some comments or questions for each other. So let's give them the privilege of talking to each other for a minute in terms of questions and answers, comments. Daniel, anything? You're good. Josh?
Maybe just a little bit. Yeah, I think the anti-entrenchment issue is an interesting one to think about. I think it's a little bit I think it's interesting to think about, especially in the Apache Stronghold case, where the government's whole argument is that RFRA just doesn't apply at all here because this isn't a substantial burden. So it seems a little bit inconsistent to say, like, you know, we overrode RFRA in this case, but we don't think that RFRA applies in this case.
Yeah, I mean, they're probably arguing in the alternative. But what's interesting is the panel decision actually thought there was something to the anti-entrenchment principle, but deemed it was waived. So they didn't reach it. So it won't be before the Supreme Court in the cert petition for Apache Stronghold. But my guess is it's not going away unless, I don't know if a Republican administration takes over next January, they'd probably be less likely to push this anti-entrenchment principle. So it may go away for a few years, and then depending on who, so we'll just have to see.
Yeah, I think the biggest issue is how this would impact so many other statutes as well. Like think about the Dictionary Act that applies default definitions across all federal law. Something like that might become invalid if you took that kind of an aggressive view on anti-entrenchment.
Thank you very much. And I might just point out the obvious, that the legislative entrenchment issue exists because religious free exercise is now protected mostly by statute and not by the Constitution, which is a really interesting thing. If you think about it, the notion of religious free exercise is right in the Constitution, but most of the protections are by statute, and that's why this issue even exists. Because if it were constitutional, it would trump any considerations of a future legislature. Well, let's go to the audience then. Yes, please. We need to have you on a mic. Do we have someone who can help us with that? But say your question, they can be thinking, and then you might have to repeat.
I had a question for you, Daniel. You had mentioned that there's not state-level RFRAs in a lot of the places where there's large Orthodox communities, and I'm curious what free exercise issues you're finding in those states.
So the question is, for those, because it needs to be on the mic, is what kinds of issues you're finding in the states, Daniel, where there are Orthodox communities, but there's no state protection?
So, like I said, our LUPA has really been a tremendous tool for the Orthodox community, and it seems, it may be surprising, but most of the issues that come up are either involving an institutionalized person in prison or a zoning issue. I haven't, I've only been with Agudath for about a year. I like to say I'm a recovering litigator. I was a litigator for 25 years. Yes, thank you. So I haven't had that much exposure. But when I asked my colleagues, what we use RFRA for, they mentioned the autopsy cases, and they mentioned how our LUPA really covers the gap pretty well.
I would just add to that all is also not lost, even in states that don't have RFRA and where our LUPA doesn't apply, because the First Amendment has been somewhat revitalized by recent Supreme Court decisions, and also in a lot of states, even if they don't have a RFRA, they might have state constitutional provisions, for example, that do provide robust protection. We have a case we're currently litigating right now on behalf of the Amish in Ohio, there's a recent Ohio law that requires all horse-drawn buggies to put an electric flashing light on top of the buggy. For decades and decades, there's been this compromise where they put reflective tape all over. They take all these other actions to alert cars, but now there's a requirement that there be an electric light on the car. And in that case, we're invoking an Ohio constitutional provision in that case that is more protective than Employment Division versus Smith.
I just wanted to add, one thing about New York, which is, there's a huge Orthodox population in New York, and what I often get calls about, it's not exactly a free exercise clause, but it's a issue, but it's a Title VII issue, which is in the workplace, discrimination against Jews in the workplace. I will say that New York has fantastic laws, among the best in the country, in terms of protection for people in the workplace, with very specifically worded statute that really gives a great amount of protection, probably more than anywhere else in the country, which is probably reflective of the fact that there are so many Orthodox Jews there. So just wanted to add that.
Is there another question? We have time for one more. Yes, please, in the back.
I was interested in specifically the issue you raised about the autopsy cases. And I guess I was interested in whether this has been viewed by the courts and the statutes as an individual right of the dead or the deceased, or a right of the family to have family members who are deceased. And is that kind of an unusual thing, either an individual right of the dead or a religious right of the family to have their family member treated in a certain way?
So it's an interesting question, and it's funny you should say that, because I was talking to a colleague of mine. I'll answer the question based on my understanding, but I think it's the individual's right. And what happened in one case, sort of a faux pas, if I may say, we apparently there was a whole hearing, lots of testimony, lots of witnesses, and for some reason the attorneys on the case forgot to bring out the very important fact that the person who was deceased was an Orthodox Jew. He observed Orthodoxy, and because of that, we lost, because that wasn't brought out in the record. So to me, that's what that says. That and by the way, now anytime we have any of these cases, we make sure to remind them, make sure you prove the fact that he's an Orthodox Jew, because if you don't do that, you're going to lose the case. So I think it is the right of the deceased.
Well, thank you very much. Will you join with me in thanking our distinguished panelists? This has been very interesting.